We have on the phone Leon Weiss of the Jeffrey Feiger firm. Leon is a 35-year veteran, well experienced in civil and criminal law. Leon has over 170 civil and criminal jury trials to his credit and a stellar record for fighting for the constitutional and civil rights of his clients. You may remember that at the end of 2010, Leon Weiss took up the defense of a man charged with a felony that carried a 5-year prison sentence for reading his wife's emails. Emails that raised questions of marital infidelity and concerns of potential violence towards the children. Of course, the case comes at the crossroads between our concerns for keeping confidential and private information stored on computers and our concerns for governmental abuse of the computer anti-hacking laws that many states have passed and of course also exists at the federal level. Leon, thank you very much for joining us today.
My pleasure, Jan.
Leon, could you tell us exactly what were the charges and bring us up to date on where the case is now?
My client was initially charged with one count for, on a home computer, this is very important, a home computer that was shared by both of them, a laptop, that my client had actually bought before the wedding, and he helped her set up her email account on that laptop. So it wasn't a work laptop for either one of them. It was a shared family computer. And he already had known her password. So he was charged with snooping at her emails, and the government, the prosecutor in Oakland County, said that falls within the anti-hacking statute. I, of course, filed a motion to dismiss, saying that it didn't fall within the four corners of the statute, that the legislative intent didn't cover this behavior. And Judge Martha Anderson of the Oakland County Circuit Court, in her what I believe is lack of wisdom, disagreed and denied our motion. Subsequently, the government charged him with a second count, and that's what delayed matters somewhat, saying that he violated the same statute by causing a computer worker at Oakland County in the law enforcement computer area to log onto her computer when he was simply asking questions about how his lawyer should word a Freedom of Information Act request. They said, well, he caused her to break into the law enforcement computer system in an unauthorized manner. Equally frivolous, if not more so. The judge also denied that motion, to quash and dismiss. And as we came up in June on the eve of trial for both of those, trying to do everything I could for my client and feeling that he was being persecuted, not just prosecuted, but, Jan, I believe he was picked out and is the only person in Michigan who's ever been charged with this behavior under this statute for private behavior. In other words, if husbands and wives want to set lines, privacy lines within their own marriage, we don't have any problem with that. It's just the government has no right to prosecute one of the spouses when that personal privacy line has allegedly been violated. So not wanting him to have to go through a jury trial on these frivolous charges, even though I feel we would have a decent chance of prevailing, I asked the Michigan Court of Appeals to stay both cases, saying that the circuit judge had committed manifest error and denying our motion to quash and dismiss. And they accepted the appeals, and as a matter of fact, the Court of Appeals opinion initially, staying the spousal email portion, said, we have serious doubts that this behavior falls within the legislative intent of this criminal statute, that this sort of domestic relations dispute would fall within that statute.